All right, well, we will go ahead and bring the House Judiciary Committee meeting to order. I want to thank everyone for being with us here today. And what we'll do is we'll go ahead and start with a prayer here today. If y'all please join me in prayer. Dear Heavenly Father, we ask for your blessing and guidance as we begin the important work that we have to do here at the Capitol today. We ask a special blessing today for the people of Ukraine, and that you look after them and guide them in this tragic time. Amen. So I want to introduce some great folks that I know that everyone just assumes that here in the office, the members, this is very, very sarcastic here. The members, are making things happen. But the truth is, if it weren't for our incredible staff, Anterica here in the Judiciary office, and also our great externs and interns, we could not, frankly, keep up with the quantity of legislation we have to cover and the work we have to do each day. And Bubba Dunn, who's an extern from Mercer Law School, is with us here today. You'll see him around the office this session. And we also have Brenda Cruz, who I think everyone has gotten to know. Brenda does great work. And so certainly if you need anything, please let them know. And we're very grateful for y'all being here. Okay, so we'll go ahead and get into the meeting. First bill we'll call is House Bill 916. And Representative Leverett, I'll just recognize you from where you are. This bill has been vetted extensively in the Gunner subcommittee and received a favorable recommendation to substitute that incorporated in some requested changes. And I know it passed unanimously out of sub earlier in the week and has not had any changes since then. So I'll recognize you, Representative Leverett.
Thank you, Mr. Chairman. And Thanks. Members of the committee, just for everybody who may not recall, this is a Judicial Council bill that would try to modernize and simplify and clarify the manner of appealing from lower courts to superior and state courts. And so this is the culmination of a very long, I think 4 or 5 year process with the council, and a lot of work, I think, by the subcommittee and committee. And Mr. Chairman, I appreciate so much your time and effort on this bill as well. And I think anyone we heard from, I believe, have satisfactorily addressed their concerns about certain language, made a number of changes, and we believe this is ready to be considered by full committee and hopefully be passed out.
Well, thank you, Representative. I want to thank Judge McFadden for being here today, for his tireless work on this. Judge Jackson from the Atlanta Municipal Court. Want to thank everyone else who's in the room who's worked on this extensively. The Judicial Council, I mean, the tireless effort, years and years working on this language is something we're very grateful for. So thank you for all your hard work. All right, this is Committee Substitute House Bill 916 LC 490852S. Is there a motion? There's a motion and a second. Any further discussion? Hearing none. All those in favor signify by saying aye. Any opposed? All right, it passes unanimously. And we've got your Rules Committee form already for you up here, Representative Leverett.
Thank you so much.
All right. I know if anybody has to get to court or anything needs to be done, you're excused. Thank you so much for being here today. Appreciate it. All right, we will next move on to House Bill 960. Representative Leverett, if you'd like to present that.
Yes, thank you, Mr. Chairman. This is the Inspector General bill. We currently have an Inspector General in the executive branch. It exists by executive order. This would give that office statutory foundation. And also the primary goals here are to allow issuance of subpoenas, issuance of warrants within that office, and also allow the investigators to be post-certified officers. This one too, we've received some input. We've made quite a few changes, which I went through in subcommittee. There are, I guess, 3 new changes on this version today, which address some comments that we received recently. And those, Mr. Chairman, are on page 2 in line, this was line 25, the definition of office. There are other inspector general's offices within the executive branch, within agencies. And some of them had requested some changes, and this was one of them, that we make it clear that the text of the statute applies to the Office of Inspector General that was created by the governor by executive order, which is the successor created by this statute. So it doesn't apply to offices within specific agencies. It's just the one that's in the actual governor's office. And so we added created by this article to the end of line 25. The other change is sort of in a similar vein. Some of those offices wanted to make clear that they were not subject to supervision and direction by the Inspector General's office we're creating here. And we had made some changes to the original bill as filed that we understood had addressed those concerns, but some additional ones were expressed. So in, let's see, this was in lines 89 through 91 at the bottom of page 4. We added a provided however language, provided however that the Inspector General shall not have supervisory authority over any such units, inspectors general, or offices. So the entire section there makes it clear that he acts as a liaison. He can monitor because we want to coordinate, make sure they don't duplicate efforts unnecessarily. He can monitor those other internal affairs units and inspectors general, but he cannot direct or control them. And then the final change was just a little, if nothing else, Mr. Chairman, sort of wordsmithing on page 7 on line 154 after produce the papers as requested. That's what it did read, and we made produce the requested items as required, because you can subpoena more than just papers. And this section deals with the enforcement of subpoenas. And then down in lines 155, 156, the language there was a bit cumbersome, and we just sort of cleaned it up a little bit to make it clear that the court enters an order ordering the person named in the subpoena to appear at certain times for certain people. So that was sort of just I guess a technical cleanup, I would say.
Well, thank you for the explanation of the changes since subcommittee. I see Scott McAfee's here, our Inspector General. Any comments you want to give, whether you support the legislation as presented here, Mr. McAfee?
Yes, Mr. Chairman, just say that absolutely support this, and thank you for everyone's consideration.
All right. Well, thank you very much for being here. We have a question. Representative Evans. I'm sorry, Representative Wilson.
Thank you, Mr. Chairman. I just want to thank Representative Leverett and Mr. McAfee for being incredibly responsive and being willing to work to get some changes incorporated into the bill.
And Mr. Chairman, if I could just say, I appreciate the input from everybody on the committee and elsewhere, and appreciate so much, Mr. Chairman, the time you devoted to shining this one up. I greatly appreciate that. I know that if you look at the job description for chairman, it does not include helping the freshman reps with their bills, but you have certainly done so on this one, and I greatly appreciate that.
It is minimal compared to the amount of time you put in. I appreciate your work with everyone else on the committee. Representative Fleming.
Thank you, Mr. Chairman. Is it my understanding that the Inspector General used to work for Burt Reeves? Is that supposed to mitigate the damages? Well, I have suspicions, Mr. Chairman, but I don't know. I might get all right with it.
Not going to hold that against you here today. All right. Any other discussion about House Bill 960? This is LC 442008S committee substitute. Is there a motion? Motion to pass. Is there a second? All right, there's a motion and a second. Any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, it's under rules. Very good. I didn't see him when I started, but it's good to see you, Judge Kell. Honored to have you here with us today. Doing the duty that lies nearest brings you to the Capitol today to get some good work done on behalf of the Superior Court Judges Council. We're grateful to have you. Yes, sir. All right, very good. We will now move on to House Bill 1352, and I see Representative Smith. If you'd like to come forward, and if you'd like to bring Mr. Belmonte with you up here, the witness chair, that'd be great. We will recognize you.
All right. Thank you, Mr. Chairman. I want to say thanks to Representative Gunner and the subcommittee. When we came in the other day, we had a good discussion, and some were online. There was some language changes that were additions that were made. I think the probate courts were probably the ones that requested that. So that's the reason we have a substitute. We put that in the bill. It was lines 54 through 58. We changed. We said that the commissioner would deliver the original copies to the appropriate probate courts. They added that language. And in lines 109 through 110, it deleted the section that talked about the commissioner would destroy the records. These records will be maintained. And also in lines 81, 82, and 88 and 89, it adds the word claimants, meaning the third party. So it makes it clear that those people have the opportunity to get the correct records when they're looking at the unclaimed properties. So those are major changes.
And this is the substitute LC 442011S. Is that right?
Yes, sir.
So could you maybe just, in case any members weren't in subcommittee, just give us kind of an overview of what we're doing here, what the existing issue is and how this will fix it.
Okay, there's quite a large amount of unclaimed property in the Department of Revenue. And if you kind of compare to us with what's going on in the United States, the rate of return on property nationally is 38%. And using Florida, I don't like to just pick out states, but they're a neighboring state. Their percentage is 59%, and Georgia's return is 9%. So we're trying to make sure that the appropriate people know that they do have unclaimed property. And even though notices may go out even on the internet, not everybody, like in my area, has the internet, but it allows that third party to come in and reach out to those people and provide information to them.
So there may be, fair to say, there may be circumstances where people have property out there, it's unclaimed currently, and we need to have a means by which that third party can claim it on behalf of that person.
Yes, that's correct. Yes, sir.
All right. We had a question, but we don't now. Doesn't look like it. All right. Okay. Any questions for the sponsor? All right. There's a motion to pass on committee sub to House Bill 1352 LC 442011S. There's a motion and second. Any further discussion? Hearing none. All those in favor signify by saying aye. Aye. Any opposed? All right. It's on to rules. And here, Representative, I'll go ahead and give you your rules form right here. So
Thank you
you'll
very
have to
much,
track
Mr.
me down. All right. Chairman Burchett, your timing's impeccable. So if you'd like to hit your button, I'll go ahead and recognize you for your bill.
Thank you, Mr. Chairman, committee members. I've got before you House Bill 1377, and this addresses an issue that has been ongoing in my district and then coming to find out throughout the state. The issue is this: if an employer, well, I'll just tell you the story that happened in my district. I had a gentleman come to me who is a contractor. And he was telling me that, his competitors were not classifying their employees correctly. In other words, they were 1099ing their employees when they should have been W-2 employees. Now, that was problematic because they're not following the law, and this gentleman was following the law. But then the pandemic came in, and now not only is there an advantage to someone that is 1099 versus W-2 in their employee, but now his employees are coming to him and saying, if you take taxes out on me, then I'm going to go work for so-and-so who's not taking tax out on me. So he's getting hit more than once because he's following the law. He's taking out the taxes, insurance, and Social Security. So I approached the departments and asked that they police these laws that are already on the book. And this is since 2019. I have been unable to get the departments to fix this situation. So the only other means I had was to draft a statute here. And what this statute allows for, it allows for a private citizen. This is somewhat like a KETAM action, if you guys are familiar. It allows a private citizen to enforce the laws of the state. So a private citizen can sue another citizen for injunctive relief alone. So the judge can say, you cannot act like this. You must follow the law. There's no punitive damages. There's a hook in there for, we're worried about one using this as a weapon. So if you win or if you lose, then you have to pay. So that was sort of to deter someone from using this as a weapon against another firm. This is sort of a last resort to try and get some relief for these folks out there that are having issues with this. I wish this wasn't the case, but this is where we are.
All right, you have a question, Representative Walensky.
Thank you, Chair, for bringing this bill. Just two quick questions. One is the only civil relief under this bill that can be brought is injunctive relief.
That's correct.
And well, two more then. And then the course will cost and expenses. Sebastian. Okay. And then I guess my question is who would have standing to bring this claim? I'm literally any person.
Any person,
and
any
is-
citizen of the state of Georgia.
Is there concern about that at all in terms of how it could be used in any way? Or no, just because it's injunctive relief?
I don't have any concern. Do you have any concern?
I haven't had my coffee yet, so people smarter than me could tell me if I have concerns.
We know how important that is, so it's available in the back. If you need some. All right, Representative Leverett.
Thank you, Mr. Chairman. Mr. Chairman, to address Representative Walensky's concern, I mean, I think that is a valid concern, but as I read the bill, someone who brings the act has to post a bond to cover the cost of damages if it turns out to be an incorrect lawsuit or frivolous or what have you.
That's correct, but it's not, there wouldn't be damages. It would just be for the cost of litigation. So we're not asking for punitive relief. Again, this is strictly injunctive relief. So if you are found to be misclassifying your employees, and many of you all know this misclassification issue is an issue that's been talked about for several years under the old dome, at least as long as I've been up here. And there's a bill currently running to address this situation. This is just another means of trying to rectify the issue.
Yes, sir. Go ahead.
And I agree, as I think my father would say, that the rule on classification of employees is one that is followed more in the breach than in the following, or honored more in the breach. But as I read the bill, though, to address Representative Walensky's concern about abuse by someone suing, it does require a bond against damages for an injunction improvidently granted. So I think that is a control, kind of like we have with prejudgment garnishments and that sort of thing. The person filing the suit has to post a bond in case they are doing in case they are bringing it just for improper purposes.
Exactly. And that was, I've been talking to the business community and trying to get them into a support posture, and certainly don't want them to come against the bill. And this is not supposed to be a means for a bully type scenario where a larger company can bully a smaller company. And so that bond is put in there so that you have skin in the game, so to speak. So you have to be, have a legitimate concern. You're exactly right. And this is, again, this is for the bad actors. The guy that came to me has finally come to the point where he hasn't gotten relief, that he says, he's given the department the names of these employers and the employees that have worked for him. And the response was that they're not in our system, and because they have never paid taxes. So he's at the point, he's at wit's end. He comes to me, he says, listen, you know what? I'm going to wind up my business under my corporation and I'm going to start a new LLC and I'm never going to pay taxes. And I said, well, don't do that. Don't do that. Let's do it right. And I don't believe he will do that, but that's the sort of posture he's in now. And I've got to figure out a way to help him out.
We have a question online from Representative Smith. You can go ahead.
Thank you, Mr. Chairman. Mr. Chairman, thank you for bringing this bill. Just to reiterate, this cost to the plaintiff would be high enough to avoid frivolous nuisance suits due to the prevailing party. winning an award of attorney's fees and the loser having to pay, correct?
I believe so, yes.
Okay, thank you.
All right, Representative Walensky.
Thank you, Chair. Just would Chair Burchett be okay if after line 22, cost and expenses, adding the words of litigation? Just to be specific. I know we understand it that way, but it's a,
I'm amendable to that.
at the proper time, I'd like to make that motion.
Representative Kelly.
And I just want to, I know there's different places in the code where if we're getting ahead of ourselves, because I was going to talk about his maybe proposed motion. I know there's other sections in the code where we have this kind of loser paid language. And so I'm just, curious for consistency, whether it says cost and expense of litigation, other places in the code, or if to be consistent, this is how it reads everywhere else, if we would want to just stay there stylistically, and maybe legislative council could enlighten us, since none of us.
I think, I'm familiar with other statutes where costs is referenced without more specificity in this type of circumstance. I think expenses of litigation, I know it is referenced that way in other statutes as well. Mr. Higbee, you have any input you'd like to give?
Chairman, this language was based.
If you'd come up to the microphone, please. We got a member online. Few members online.
Yes, Chairman, this language did come from existing code. I have no doubt that it's worded both ways in different places. So yes, Chairman, I agree with you.
All right. Okay, any follow-up questions for the sponsor? All right, I don't see any. What is the will of the committee? There's a motion to pass from Representative Evans. Is there a second? Motion and a second. All right, this is House Bill 1377 as introduced. Any amendments or discussion? Representative Walensky.
Chair, I'd like to just add in the words of litigation, line 22 after expenses.
All right, the proposed amendment is after the word expenses on line 22, add of litigation. Is there a second? Second. All right, there's a motion and a second. Any discussion of the amendment? Hearing none, all those in favor of the amendment signify by saying aye.
Aye.
Any opposed? No. All right, in the opinion of the chair, the ayes have it. All right, so now before us is House Bill 1377 LC 441989 as amended. This will be a committee substitute as it comes out with the amendment that we just had. Any other amendments? Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right, it passes. It's on to rules. Chairman Burchett.
Thank you, Mr. Chairman.
I have your rules committee form up here, so we'll get together after committee. All right. House Bill, I believe it was 1388, which was on an agenda we had put out. That is not going to be heard today. The only remaining bill on our agenda is House Bill 1383. Is there anyone here from the Equal Opportunity Commission?
Not today. No.
All right. Representative Walensky, your mic's already on. So if you'd like to go ahead and present House Bill 1383, we'll hear from you.
Thank you, Chair. This is brought to us by the Georgia Commission on Equal Opportunity. I had a very long conversation with the chair of that commission. And this is just a cleanup bill. This has been needed for a long time. There hasn't been a cleanup bill in a very long time. And it's really just making minor changes and removing some redundancies in the law, especially when we get further into page 7 and page 9. The removal of those is merely because it was already identified in this code section or in other code sections, and it's not changing anything. It's not really changing things, it's cleaning everything up. The only real change it does is help with the reporting of complaints where there's been issues with in very difficult, complex matters that they had to report back in 90 days, where this has them still reporting back, but gives them the ability to report back that they need more time and they are working on it. So that's the only substantive change that I noticed, but everything else is really clean up and it's very straightforward.
All right, very good. So this is a department bill that was requested by the department, and that's the genesis of this. Anybody have any questions, or does anyone need additional time to review the bill? All right, well, here is what I'm thinking we will do. Because no one is here from the department today, we're going to hold this bill at this time so that we can give them an opportunity to come. We're going to need their signature anyway on procedurally in order to move this forward. So we'll give Director Cross or someone who works for her an opportunity to come and be present for us to consider the bill. And I expect we're going to have a hearing first part of next week. So we can get it moved well before crossover day. All right. Anything else that's good for the committee?